Hello. We are presenting our case briefing, but before we get into it, we will introduce ourselves. I am Stephanie.
I'm Sally.
I'm Jana.
And I'm Melanie.
And we are going to be presenting on, making sure I can get my screen shared. We will be presenting on the Winkelman versus Parma City School District, which was a Supreme Court case that influenced the future rulings of any complaints filed against the IDEA Act. Well, not filed against the act, but filed against school districts for violating the act.
The plaintiffs in this case were David and Sandy Winkelman. They were petitioning on behalf of their son, Jacob. Jacob was a 6-year-old boy who has autism spectrum disorder. He was a student at Pleasant Valley Elementary School in Parma, Ohio, which was part of the Parma City School District. When the parents and the IE team could not reach an agreement on his IEP, the parents filed a complaint alleging that the school district had failed to provide Jacob with a free, appropriate public education.
Some of the facts of the case, Jacob's parents worked with the school to try to develop an IEP for him. An agreement could not be made, and because of this, the parents filed a complaint and received an impartial due process hearing. The proposed IEP placed Jacob at a local public school. After the initial complaint was rejected and the appeal was rejected, Jacob's parents filed a complaint at the United States District Court. They stated that Jacob was not receiving FAPE or a free appropriate public education, and his IEP was inadequate, and that the district failed to follow procedures of IDEA. Jacob was then enrolled at a private school. The parents had to pay tuition there while they waited for the results of the complaints. After the United States District Court found that Jacob was receiving FAPE, the parents petitioned the Court of Appeals at the Sixth Circuit, where they were dismissed unless they received counsel to represent them. Following that, the case was then taken to the U.S. Supreme Court by the parents. All right, so the timeline, 2003 to 2004 school year and administrative hearings. The Parma City School District, Pleasant Valley Elementary School proposed an IEP for Jacob that the parents disagreed with. The parents stated that the IEP was inadequate and he wasn't receiving FAPE, so they initiated administrative hearings under the IDEA. The Winkelman's complaint was ruled against, and they filed an appeal at the state level where they were again ruled against. In 2004 to 2005, United States District Court for the Northern District of Ohio, the Winkelmans continued by filing a complaint against the school district at the district court level for the Northern District of Ohio. The U.S. District Court ruled in favor of the school district again, stating that Pleasant Valley Elementary School did provide FAPE to Jacob. In 2005, Court of Appeals 6th District, the Winkelmans appealed the decision of the U.S. District Court to the United States Court of Appeals 6th District. Because the parents were representing themselves, the Court of Appeals dismissed them. They stated that the parents were unable to represent their child's best interests without an attorney at that level.
The lower court decisions, upon losing their appeal to both the school district and the state level review, the Winkelmans then filed a complaint with the United States District Court. The district court ruled in favor of the respondent. The school district said due to the findings that the school district provided Jacob FAPE. The Winkelmans proceeded without counsel and filed an appeal with the Court of Appeals for the Sixth Circuit. The Court of Appeals dismissed this case unless the Winkelmans obtained counsel to represent Jacob and themselves.
2006. So we're going to continue the timeline here after the lower court holding. 2006 United States Supreme Court, the Winkelmans requested a review of the decision from the Court of Appeals, where they were told to obtain counsel or that their case wouldn't be heard. In 2007, the Supreme Court decision determined that the parents were able to represent their children under the IDEA without obtaining legal counsel, that they had that right to advocate for their children.
Okay, the rationale and the court's holdings. So the holding of the court was they held that the parents have the right to proceed to represent themselves on behalf of their child in a federal court under IDEA. They come up with the key points of the holding included parental rights under IDEA. The court affirmed that IDEA grants parents significant rights, including the right to participate in decisions regarding their child's education and the right to challenge decisions through legal processing. The interpretation of IDEA, access to judicial review and policy consideration, allowing parents to proceed, promotes parental advocacy, and ensures that disputes over a child's education can be resolved promptly and efficiently in accordance to the best interest of the child. The case was then sent back to the lower courts to rule on the original complaint, which ruled in favor of the school district. The rationale behind Winkelman versus Parma City School District is that the court recognized that IDEA grants parents substantial rights and responsibilities concerning the education of their disabled children, including the right to participate in decisions regarding their child's education and to bring legal action to enforce those rights. It was argued that denying parents the ability to represent their child in a federal court proceeding would undermine these rights and then hinder effective parental involvement in the education process. The court interpreted the language of IDEA to broadly support parental involvement in legal proceedings related to their child's education. IDEA allows parents to pursue administrative due process procedures and, if necessary, to file suits in federal court. The court found that the statutory framework includes the right of parents to represent their own interests and the interests of their child in federal court, even if they are not attorneys. This gives them access to justice and procedural fairness, and it also protects their child's rights. Parents are often in the best position to advocate for their children and for their educational needs, and the court recognized that empowering parents in this way serves in the best interest of the child. Okay, the scope of the holding and the primary implication. The scope of the holding in Winkelman versus Parma City School District, it refers to the specific legal principle established by the Supreme Court. The court held that parents have the right to proceed in federal court on behalf of their children. This decision clarified that IDEA does not prevent parents who are not attorneys from representing their children in court if it is related to special education disputes. The scope of the holding is narrowly defined to address the procedural rights of parents under the federal law in the context of special education litigation. The primary implication of the Supreme Court's decision, it affirmed and expanded parental rights in advocating for their children's education under IDEA, and it allows parents to represent their children in courts. And this decision empowered parents to directly participate in legal proceedings without the necessity of hiring legal counsel. The decision had practical implications for parents who may not have the financial means to hire attorneys or who prefer to advocate personally for their children's educational rights. It also underscored the importance of parental involvement and advocacy in special education disputes, ensuring that parents have a voice in the decisions affecting their child's education. The legal precedent. There wasn't a legal precedent used in this case, but this case became the legal precedent. Winkelman versus Parma City School District established a legal precedent that affirmed that parental rights in special education cases influencing future interpretations and applications of parental rights under IDEA.
To kind of piggyback off of a lot of what Melanie just talked about, the SCOTUS ruled that parents have both substantive and procedural rights under IDEA. Most federal appeals courts in the past have ruled that parents couldn't proceed without a lawyer when a dispute brought families and school districts to court. Subsequently, the school districts were then bringing said families back into court on charges of violating state statutes against the unlawful practice of law. For parents who either couldn't afford legal representation or find a legal representative willing to take on their case, this was detrimental in their efforts to protect their child's educational rights protected under IDEA. This ruling allowed for opening the doors to federal courts that had previously been closed to parents seeking justice on behalf of their children protected under IDEA. And this ultimately allowed for heavier parental involvement in the development and execution of a child's IEP and their federal rights under IDEA.